Legal disclaimer. This video was created and published by an individual, not a corporation, and is intended solely for informational and awareness-raising purposes. It does not serve as an advertisement or endorsement of any product, individual, or corporate entity. The events depicted in the video are real and have occurred as presented.
Mr. Coleman, I need to advise you of your rights with respect to this proceeding. Ms. Choi has probably told you all of the things that I'm about to say, but I'm obligated to do this on the record. So you have a right today to have a fully contested hearing for the court to determine where Paris would be placed, whether with you, with her mom, with her grandparents, and what visitation you would have with Paris. You have a right to counsel during this hearing and throughout this dependency proceeding. You have a right to cross-examine any evidence the department would present to the court, present any evidence that you would like to present, including your own testimony, the testimony of other witnesses or documents. And then you have the right for the court to make its decision based solely on the petition filed by the department and the evidence during the hearing. Do you have any questions about your rights today?
You have to say yes or no.
No.
Okay. Do you have any reason to believe that Paris has any Native American Indian heritage?
A little, yes.
Okay, tell me about that.
I think through family talking at when I was home in Mississippi.
Can you say that again? I'm sorry.
I think through like family talking when I was at home in Mississippi.
Okay. Do you know what tribe?
I think Navajo.
Navajo?
Yeah.
Okay. Mr. Thorson, do you have any more specific questions about the ICWA?
I guess just to be clear, Mr. Coleman, is Navajo the only tribe that you have like the name of?
I have a moment.
Of course, yeah.
And at this point, he does not have any information to share with the court that he knows for sure.
Okay, only the Navajo.
Yes.
Okay, thank you. And are you in the military?
No.
Okay. All right, so I understand that there is a proposed agreement. I have reviewed it, and I just have a question for the parties. In section 2.7, which is the finding that the court needs to make about shelter care, there is nothing about Mr. Coleman in there. And the court would observe that Mr. Coleman is currently in custody, and that may be the basis for his unavailability to parent Paris, but the order doesn't say that. And so I'll just ask if the parties want to consult, you may do that, or you may say out loud if that is indeed the basis for unavailability. Ms. Choi, do you need to consult first?
If it's fine with the court, I would ask the opportunity off the record to confer within the parties. I am optimistic that we will be able to agree on the language, and thank you the court for spotting that issue.
Yeah, I mean, I have to make a finding that about Mr. Coleman specifically, and so I'm just observing that a potential finding is that he is incarcerated. So, officers, would you allow Mr. Thorson and Ms. Choi to consult and leave Mr. Coleman? Okay, Ms. Choi, if you all would just step over here and consult, and we won't go off the record. I don't think it'll take you very long.
It's gonna be okay. Yeah, actually.
Your Honor, the parties have reached an agreement in 2.7 to revise it so that that first checked box that the child has no parents to provide supervision or care for the child, to make that specifically as to the father, and the remaining findings as to the mother.
As to father, because he's incarcerated.
Yes, we can certainly have that.
Yeah. Because I mean, he's sitting here, so I can't say he's in the wind. All right, so the court will find that Mr. Coleman specifically is not available at this time to parent Paris because he's incarcerated. I did review the other parts of the agreement. Given Mr. Coleman's statement on the record that he believes he may have Navajo heritage, the court is obligated to find that this is a reason to know case. So under 2.2, the court will find that there is a reason to know and will order the department to, of course, follow up as in its normal course to send out inquiries about that. Is there an agreement as to active efforts, Ms. Choi?
Yes.
All right, Mr. De Los Reyes?
Yes, Your Honor.
All right, so the court will find, based on the recitation of efforts in the petition, as well as what is already included in the order, and with respect to Mr. Coleman in particular, active efforts, because of his unavailability and the reason for his unavailability, active efforts would not have avoided, would not have made him available. All right, so the agreement is, and so Mr. Coleman, I'm going to do my best to recite the agreement, and then I'm going to ask you if you have any questions, okay? The agreement is that Paris is placed with maternal grandparents Douglas and Sherry Eglinton, that the mother is allowed to live in the home while Paris is there, as long as mother continues to work with her DV advocate, agrees to have a mental health assessment by a trauma-informed provider and follow treatment recommendations. The department will assist in making the referral. That mother agrees to engage in a substance use disorder assessment and follow treatment recommendations, and the department will make the referral. Mother agrees to do 1 random UA per week, minimum of 1 between 8:20 and 8:27. Okay, so this order will be entered today, and so that has gone, so that language will need to be amended. Has a UA happened?
No, it has not yet. The mother did miss one, and then a second one was missed because she is currently in the hospital.
Okay. So is the department changing?
Oh, and she submitted a UA at the hospital.
She submitted it, okay. So let's make 4 accurate. I'll let you all work on subsection 4 because it's no longer accurate. Number 5, the child will sleep in the room of the grandparents, and mother shall not sleep in the same room as the child. And all contact between the mother and the child shall be supervised by one or both of the maternal grandparents or another responsible adult approved by the department. The grandparents will not allow any substance use in the home, excluding prescribed medications, and they shall keep the home clean and safe for the child and promptly notify department of any substance use or any concern for the safety of the child. And then for father's visits, you all have agreed to 1 video visit per week supervised by the department or the designee. And once Mr. Coleman is released from custody, then 2 visits per week for 2 hours each supervised by the department or its designee, and visitation may be expanded by agreement of the parties. The court is also appointing an independent advocate for the child, a guardian ad litem or CASA. Okay, did I miss any part of the agreement, Ms. Choi?
I don't believe so. Thank you.
Mr. De Los Reyes
But not that I'm aware of, Your Honor.
and Mr. Thorson.
Oh, no, Your Honor, I guess the only thing I would maybe point out, section 3.13 is there for benefit of Mr. Coleman.
3.1 sub 3, the agreement.
It's 3.13. It's the very last section, there's a paragraph that's essentially Alfred language.
Oh, I see, 313, got it, all right. Well, there aren't any facts in here about him, as I pointed out. The only fact that I'm finding is that he's incarcerated, and I don't think he has a Fifth Amendment right with respect to that, because he's incarcerated. So fine. So I'm not sure 3.13 is necessary, but. All right, Ms. Choi, do you want to consult with Mr. Thorson and Mr. De La Reyes one more time on the amended language to 3.1 sub 4, which is the updating the UA language?
No, I don't have a position.
Okay.
Your Honor, I guess technically the mother she did provide one between the 20th and the 27th. We just don't have the results yet. But I can certainly reflect that kind of tweak to the fact that
Okay.
the UA was done at the hospital. Results are.
Okay. All right. Yeah, why don't we just have it say mother has completed, mother agrees to do 1 random UA per week. And then in the parens, 1 UA was provided between 8/20 and 8/27 or whatever date you want to say. Okay.
You all right?
All right, Mr. Coleman, do you have any questions about the agreement?
No, ma'am.
Okay, and is it your desire to enter into this agreement rather than have a contested hearing today about where Paris will be?
Yes, ma'am.
Okay. All right, then I will enter the agreement. The next hearing on this matter will be 9/17. Is that still the right date?
Yes, that's correct, Your Honor.
Okay, will be September 17th at 8:30. If you are still in custody and you and your lawyer decide that you need to come to that hearing, you will be transported. Sometimes if the parties reach an agreement, there might not be a need for you to come, but your lawyer will let you know one way or the other. From here forward, make sure that you know who your assigned lawyer is. Ms. Choi, are you staying on?
Yes, I am.
Okay, that you know how to get a hold of Ms. Choi and that you stay in contact with Ms. Choi. The current social worker is Ms. Summers, but that is going to change. There's going to be a different social worker assigned who will be on it for a long time. Make sure that you get the new social worker's name and number from Ms. Choi so that you can reach out to the social worker and ask questions if you wish, so that you can keep abreast of what is happening with Paris. If there's any problems with the visitation, then that would be an issue. For example, you may want to call the social worker about and say, hey, I'm not getting my visits, what's going on? You can also call Ms. Choi. There also is an organization called Parents Supporting Parents that is staffed by parents who have been through this very same process. They have sat where you're sitting. They know what it's like to have their kids taken into care and go through a dependency. Ms. Choi can give you their contact information. You can call them. Sometimes they come and visit folks in county. I don't know whether they will, but I'll leave it to you and Ms. Choi to decide if you want to accept that support from them. And then should we set a mediation date or not at this time?
I think the parties have discussed setting at least 1 mediation date, either bifurcating it or setting 2, but I think the parties have agreed to waive a case conference.
Okay, so we're gonna set a mediation, which is an opportunity for you and your lawyer to sit down with the parties and come to some sort of agreement if you're able. At least sometimes people come to agreement on some things. And so that date will be October 2nd. Okay. And again, Ms. Choi will let you know how you can participate in that, whether it's in person, by Zoom, or on the phone. Do you have any questions for me about Paris?
No, ma'am.
Okay. I think that's everything. All right, that will conclude this matter. I'll see you on the 17th, Mr. Coleman, or another time in the future. Yes, Mr.
Your Honor, just a tiny bit of housekeeping. The
Yes.
order setting case schedule, for some reason, said that the 30-day shelter care hearing is at 8 o'clock.
Oh,
That's, so I put 8 o'clock in this, but I would propose just changing it to 8:30.
Please do.
Yes.
None of us will be here at 8 o'clock.
Take care.
I think that's it.
It's a pleasure seeing you. I'll pass.
Thank you. Thank you all for what I told you about that. Officers, thank you very much. Okay.
Yes.
Okay. You want to go straight through?
Oh, you don't have to.
Oh, you got, hold on.
Okay, thank you. Thank you.
All right, let's move to Ryder Westbrook.
Oh, never mind. You will share my
So
screen.
we will go on the record on Ryder Westbrook, just to confirm we still have everybody, Ms. Cunningham, Ms. Matthews Bobby, and is Mr. Westbrook still on the Zoom, Ms. Lynn?
I believe so. He is titled as Jamie Moore.
Great, and we have.
Oh, I apologize. I got disconnected from Zoom at some point, but I am getting back on there.
And Ms. Moore is here with Ms. Griffiths, and let's just get Mr. Westbrook and we'll go from there. All right, so I did review the department's motion and attachments, and then the update from Ms. Matthews Bovee that was filed yesterday morning with the UA results, and the I think what's quite important is Ms. Westbrook's expressed desire to go to treatment. So I think the most efficient thing to do at this point, Ms. Cunningham, if you don't mind, unless you have additional supplement, I would be inclined to hear from others and then hear from you last. Do you have additional supplement?
Well, Your Honor, the parties have, I think, reached something of an agreement.
Okay.
So I think that counts as supplement, but not in the way that, obviously. So, Your Honor, I spoke with Ms. Griffiths and Ms. Slimp this morning. The child is currently placed with a suitable other placement, Ashley Simpson. And the department understands from Ms. Griffiths that Ms. Moore is interested in going to Lifeline for a PPW in Vancouver, Washington.
PPW is?
Parents, pregnant women and children.
It's an inpatient facility where she can have Ryder with her.
Yes.
Okay.
Excuse me.
Thank you. That's okay.
So this would be, as Ms. Matthews Bovee just very helpfully pointed out, that this would be a inpatient treatment facility where Ryder could be placed with her mother. The department is willing to agree to placement in the PPW on the condition that the PPW program be, maintained until the completion of the program. That Ms. Moore
She'll stay in the program until she finishes.
Yes, but
if she leaves, that
would
mean that Ryder leaves her.
correct.
Okay.
Of course, because this is being kind of worked out as this is happening, the parties have, I think, agreed to Ryder remaining in the current placement that she's in until Ms. Moore is at the treatment facility, and the treatment facility says, yes, she is stabilized. We are ready for Ryder to come to be placed with her. The additional sort of thing that does need to be worked out, I think this was mentioned to Your Honor the last time we were on the record. The placement works, she's a nurse, she works a very long shift on Tuesday and every other weekend. So the parties are agreed that the paternal grandmother, and only the paternal grandmother will go to the caregiver's home. And the caregiver has already been consulted on this and has said yes to this.
Okay.
As did the paternal grandmother. As did the paternal grandmother, yes.
So just because there's lots of Westbrooks.
Tracy
Westbrook will
Correct.
go to the Simpsons home, and care for Ryder during the periods Ms. Simpson is on her long shifts.
Yes.
Okay.
So that is sum and substance in terms of the agreement. In terms of Mr. Westbrook, Mr. Christopher Westbrook, who is the father, I think the department would ask for the court to maintain the prior visitation order, which still has his visits as being monitored at 15-minute increments, 6 hours per week, 2 hours per visit, or whatever is worked out. And that be by DCYF or DCYF designee. And then
Hell no.
mom's visitation, I think we would probably ask for a similar visitation plan for the mother until she's in treatment, and then treatment is going to make visitation, I think, a little bit difficult because I don't know how the blackout period with treatment is going to work with visitation. So I think that's kind of to try and cover all of the basements in terms of placement, like where the child is placed, what the plan is for mom, and what the visitation plan is.
And is the blackout prior to Ryder going? Or is Ryder there for the blackout? Or
At
do
the
you know?
facility?
Yeah.
No, Ryder would be placed with Ashley Simpson until during the blackout period.
So Ryder would not go to the treatment facility until after blackout?
Correct.
Right. Okay.
And I think, Your Honor, also under I think it's RCW 1334-138, we would also need to have an interim review within the next 30 days. So that would be the only other thing sort of added into that.
All right, Ms. Slemp.
We are under some understanding that visits were changed to unsupervised, and that had been changed in one of the orders.
Somebody find me an order, and then I'll hear from Ms. Griffiths while you're finding that order.
Yes.
All right, Ms. Griffiths.
Yes, thank you, Your Honor. We are in large agreement with the plan that Ms. Cunningham articulated, and it's really been, I think, all the parties putting that together this morning. Thanks to Ms. Slemp, Ms. Moore and I were able to contact Lifeline and confirm that there is a bed and what the steps Ms. Moore needs to take today and tomorrow morning to hopefully get that bed as soon as possible. Ms. Moore would say, she told me that this is the hardest she's ever been working this whole case. And she does agree that she relapsed. She agrees that she told DCYF. She would agree that the UA that she took last week is going to come back positive. And she is, I think, very committed to going back to inpatient. It worked really well for her once before. Unfortunately, she left. She was forced out of that program early due to insurance expiring, and then returned to a living situation that was just not very stable. And Ms. Moore would agree that she doesn't think that the home with paternal grandpa is safe for Ryder right now.
This is nothing to do with this order today, but as I was preparing and I was looking at my notes from when we were here last, it looked like housing for Ms. Moore and Mr. Christopher Westbrook and Ryder was close to fruition and that was that May or June? What's going on with houses?
We've been really close for a long time. Okay. It's just finishing certain steps that either things have fallen through, apartments, get taken before she finished the application, but there's been certain steps that haven't been completed.
Can Mr. Westbrook continue working, Mr. Christopher Westbrook continue working on the housing while Ms. Moore is in treatment?
I would need to submit a separate voucher for him, as this current one's only under Mrs. Moore right now.
And what's going to happen to her voucher when she goes into treatment?
I was told if she was to do a shorter term one, they would have been able to keep it open. However, I don't think they'll be able to keep it open over. I do need to confirm with them that. But my hope would be to help instead of going into like an apartment transitional housing and supporting her in that instead of focusing and hoping on the FUP voucher. Because I don't think she'll be able to keep it throughout.
She'll need one eventually.
Yes.
Mm-hmm. The family's going to need a FUP voucher.
Yes.
Eventually.
Yes.
And so I'm not going to make an order about that, but just don't let that go by the board while this is happening. And if it needs to be transferred to, if the family is intending, which it seems that the family is intending to stay together in the long term, and that everyone agrees that they need their own place, then transferring it to Christopher Westbrook seems like a potential,
I will see if that's possible, of like transferring it is,
or getting a different one.
or yeah.
Just don't let the house, because if she gets out of treatment and they don't have a place to live.
I don't
then-
want to do that all.
Right, we don't want to do this all over again. So,
Yeah.
okay, Ms. Flint, visitation.
Oh, Your Honor,
Oh,
if
sorry.
I may, I
Oh,
just
yeah,
had
sorry.
a few more things that I wanted to address. My understanding is that I have had clients who have been able to keep their FUT voucher while they're in inpatient. So I will work with I think that should still be possible,
Okay.
and we would not object to being transferred to Mr. Westbrook, but Ms. Moore's understanding is she can keep the housing.
Whatever needs to happen to be able to keep the housing ball rolling.
Additionally, this has just been really, really hard on Ryder. Miss Moore let me know that the caregiver told her that she's crying all the time and that she's really struggling. And so we are asking for very liberal visitation. We're asking for at least 4 visits a day, for four visits a week for 4 hours each day. Unsupervised, the department, I think, had agreed to mom's visits being unsupervised pending this continuance. I don't think there's been any safety threats from Ms. Westbrook herself that have been alleged. So we would ask for a minimum of 4 visits per week for 4 hours unsupervised. And if Tracy Westbrook is able to facilitate more, then Ms. Moore would jump at that. Lastly, Ms. Moore learned after the continuance was granted and Ryder was temporarily placed with the suitable adult last Thursday, that she was cut off from Ryder's daycare portal. And so she's not able to get updates about how she's doing or see photos of her. And she would ask that access be immediately reinstated so she can get those updates.
So, Ms. Matthews-Bovey is going to have to check with the daycare, because her only concern, I think, is how many people are allowed to be on the portal, as to whether or not because the department would not be agreeing to, for example, Ms. Moore picking Ryder up if the portal is limited to only individuals who can pick the child up or something like that. But I think
That sounds like you all can work that out.
right.
Or they would have
prevent bringing it up as a.
Of course.
Please
Of
help me
course.
with this.
Of course, and I think I need to make one correction after speaking. I think the department had agreed to, I will inform the court that visitation occurred over the weekend with the suitable other placement with Ms. Moore at Ms. Simpson's home.
No, sorry, we had a visit transporter, and it occurred at, I believe, a park by the community center. Mrs. Moore can correct me if I'm wrong.
And that visit was unsupervised.
Yes.
So the department.
Both visits, one occurred on Saturday and one on Sunday.
For 3 hours a week.
I understood the department didn't have any objection to unsupervised.
Correct, and I think I made it sound like it should be monitored. That was my mistake.
Yeah.
So unsupervised visits.
And then as to Christopher, the department is asking whatever has been previously ordered to stay in place.
Correct, and my
So I'm
understanding, the
looking
order.
at the prior order, which
What?
was submitted and signed by you on July 5th. And under the visitation section, under 314, it says specific visitation plan, NA. Child with mother. So to me, that makes it clear that visits were unsupervised. There was no supervision ordered in that order. There was no level of supervision. There was no box that said prior orders. It was very clear that there was no organized visitation plan with supervision for my client.
Yeah, under 2.7, it says not applicable, and under 3.14, it says not applicable. So, that is.
I understood that as to be relating to visitation as to parent one only,
Why is that? The order doesn't say that.
Well, it's as to there is a finding under 2.17 for parent one, and there is one under 2.18 for parent two, that the parent had been visiting regularly. I'm not sure why that box wasn't checked.
2.20 doesn't address it at all.
I'm sorry, you're at a 2.20.
2.20 under the prior court order, that's not checked. And then under 3.14 and 3.15 with 3.15 as parent 2 is not checked. And I'll look at my notes. I mean, my impression in July is that the department's getting ready to dismiss this case. And Ms. Matthews Bovee is nodding her head. So, I don't have any reason to think that visits with dad were anything other than unsupervised at that point.
Understood, Your Honor. I think that the department then would be, can I just ask Ms. Bovee's Matthew a question?
Go ahead.